Welcome to this Legal Aid New South Wales webinar, All Things Divorce. Before we begin, we will like to acknowledge the traditional owners of the lands from which we are broadcasting today. I'm broadcasting from the land of the Widjabul people of the Bundjalung Nation, and Cailey will acknowledge the land. Cailey, would you mind letting me know the land that you're on?
Yeah, the Awabakal people.
Thank you. And Cailey's broadcasting from the land of the Awabakal people. We pay our respect to the elders of this land, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people attending today's webinar or watching the recording. As I said, this webinar is called All Things Divorce. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. This webinar will be an hour in total, including time for Q&A. After the webinar, you will receive an evaluation survey, and we do appreciate your feedback and take that into account in our webinar planning throughout the year. You'll also receive an email with information about the resources that Cailey refers to in today's webinar. I'll hand over to Cailey now. Cailey Campbell is from Legal Aid's statewide advice team. Thank you, Cailey.
Thanks, Bridget. Hi, everybody, and welcome to All Things Divorce. I'm really hopeful that today we can all learn a thing or two from each other and that this webinar assists either your direct self or anybody that you're trying to help or support navigate their way through applying for a divorce, responding to it. It's a pretty emotional and kind of complicated area of law sometimes. This list here shows a bit of a snapshot about what we're going to talk to you about today. So we'll start by talking about the actual separation itself, what a divorce is, when you can get one. We'll then go through the more formal process of actually applying for or responding to a divorce and what happens at and after court. The last thing we'll do is go through some actually really helpful DIY resources, as well as discussing if any of you or your people who you're supporting need legal assistance, how you can go about getting that if you need it. So starting at separation, because we can't even consider getting a divorce unless we have been separated. Rule number one, we need to know the date of your separation. So the court won't accept a rough month or mid-2021, we need a day, a month, and a year. And usually this is when we have that conversation, I'm separating from you, it's over, see you later. You don't necessarily have to have proof of this. It can just be in the conversation itself. But if you have it captured in a text message or an email, definitely hang on to that just in case. And this is because the date for separation can be disputed at times, and the court may want some further assistance or some evidence to help it determine what the likely date of separation was. And the reason the court's so focused on this and why it's so important that we get that exact date is because the court cannot make a divorce order unless it's satisfied that the parties have been separated for 12 months. You can apply for a divorce after that 12-month period, but we need to make sure that that 12-month period has lapsed before we can even consider asking the court to make a divorce order. And when we talk about separation, I suppose a really common question that we get is, can we separate even if we're still living together? The answer is absolutely yes, you can. There's two camps. So you've got your physical separation camp, which is conversation or statement rather. I'm separating from you, and then one person moves out of that property or out of that family home. And then you've got the other camp, which is separation under the same roof. And this can be a little bit more complicated, and the court will definitely need further information from you if you're applying for a divorce and you have been separated under the same roof. So we're still having that conversation. I'm separating from you, but instead of moving out, we're continuing to live together. The things here in the lighter green color are the things that you really need to consider if you're choosing to separate and live under the same roof. We're ideally doing separate bedrooms. If you don't have a separate bedroom, we're kind of separate sides of the bed and we're not having that sexual relationship. No shared meals, we're not dining out together as a couple, we're not cooking each other's meals for each other, we're separating our finances, we're dividing living expenses, we're dividing household chores, so we're not doing their laundry. as I said, we're not cooking for the other person. We're making sure as much as possible, all of those types of things that you would usually do as a couple is now separate. A really good one is friends and family and their view of your relationship. The court will require, as it does you, evidence to support separation under one roof. They may also require a third party. And so this is if you've talked to a friend or a family member, their knowledge of your relationship as being over and not viewing you guys together as a couple is also really important and crucial. And then a more formal kind of notification to government departments is a good one too. So if you're on, for example, a single parenting, sorry, a partnered parenting payment, and you're changing that, you're notifying Centrelink and moving towards the single parenting payment. That's another way that you can show that you are separated despite still maintaining that residence together. Once 12 months of either physical or under the same roof separation is up, we then move on to the actual divorce itself. So I suppose before we go into this, I just want to make it very, very clear that if both parties agree, you never have to get a divorce. You can remain separated until you pass away. There's no requirement for a divorce. It is simply a choice of yours. So if you do choose to get a divorce, it's probably important to know what a divorce is. And sometimes there's a lot of confusion about divorce, parenting, property, which is which, what's what, are they all the same? And to answer that simply, it's no, they are all very, very different. They all have different laws that deal with each of them. They have different court processes, different types of applications, different orders that can be made. And ultimately, when we say, I want to get a divorce or I'm getting a divorce, it's where the Federal Circuit and Family Court of Australia make an order that says your marriage has legally ended. So it's not dividing assets of a relationship. It's not organising parenting arrangements. Those things are very, very separate. When can you get a divorce? We in Australia have a no-fault divorce system, so the court doesn't consider why a marriage ended or whether one of the parties were responsible for ending it. The only thing that the court looks at is these things. So I suppose I might just start down to this one here. So first, to have standing, the ability to be able to apply to the Federal Circuit and Family Court of Australia to ask them to make a divorce order, you need to either party needs to be an Australian citizen, regard Australia as home and intend to live in Australia indefinitely, or ordinarily live in Australia and you have done so for the previous 12-month period. If that box is ticked, amazing, you can apply. And then what the court considers when making a divorce order is step one, are you guys legally married? The court's not going to make a divorce order if you're not legally married. When we talk about being illegally married, we're looking at things over to the right here about already being married previously. Being in a prohibited relationship. So if you're, for example, marrying your brother or your sister, that's a prohibited relationship in Australia. If there's no real consent that's been obtained for the marriage, so if the person who married, for example, doesn't have the cognitive capacity to say yes and understand what they're entering into, or if somebody's underage. There's that requirement for 12 months again. That's probably one of the most important ones. Marriage has broken down irretrievably. This ultimately means that you and your ex-partner are simply not going to get back together again. The court also needs to be satisfied that there's proper arrangements that have been made for the care of your children. So this is only your children that are under 18 years of age. It doesn't need to be in the form of parenting orders or a parenting plan or any written agreement. It can just be something like a verbal agreement. And then the last one is that if you married less than 2 years ago and you're applying to the court for a divorce order, you also have to obtain a counselling certificate. I've attached a little link just underneath that to a website that you can use to be able to find a marriage counsellor if this is the circumstances that you're in, but you do need that counselling certificate. And basically that is you organising an appointment with a counsellor with you, your counsellor and your ex-partner to discuss reconciliation. And your counselling counsellor will be able to provide you with that certificate saying that they've had those discussions with you about reconciliation, and regardless of this, you're still making the choice to apply for that divorce order. If all of those boxes are ticked, you then have the green light to start the divorce process, and this is a bit of a very, very brief snapshot of what this looks like. So For a divorce, everything is applied for online these days. The registries, if you go in person with all your documents, you might experience a bit of pushback. So it's really important that we try to submit everything online. And you can file 2 different types of applications. So you can either do a joint application or a sole application for divorce. A joint application is where you and your ex-partner agree and you're going to file together. A sole application is where only one party is filing for that divorce. So if you've done a joint application, you don't even need to worry about requirements of service. So you can just ignore me when I'm talking about service. But if you've done a sole application, it's really important that you listen to me when I talk about service, because it is something that you definitely need to do. And when we talk about service, it is basically giving them copies of your court documents so that they're aware of the court proceedings. So once your partner, if the requirement for service is necessary, has been served with the court documents, they then need to choose whether they're going to respond to the application or whether they're just simply going to do nothing. Then after they decide to do either nothing or respond to the application, you'll then attend the hearing. And at the hearing, either a couple of things can happen, but usually the court can just make a divorce order on the first day. It might want a few extra I's to be dotted and T's to be crossed, in which case it might adjourn the proceedings to a later date and give you specific and clear directions about what you guys need to do or file to be able to satisfy the court that a divorce order can still be made, or it could ultimately dismiss the proceedings. But to go into a little bit more details about this process, first we're going to look at how we actually apply for a divorce order. So step 1, we need to gather all of our supporting documents. Now, I've done a bit of a traffic light approach here, so I hope this kind of assists. But in red is the marriage certificate, and this is to an extent a non-negotiable. We really need a marriage certificate. If you don't have one, you need to apply to Births, Deaths and Marriages for a copy of one, or you need to make contact with the country where you were married in to be able to obtain a copy. In orange, we've got the documents that are required if it's applicable to you. So if you have, for example, changed your name, and that's different from your marriage certificate or your maiden name, you might need to do a change of name certificate. If you've been married less than 2 years, as I just talked about previously, the counselling certificate, you'll need that. If you weren't born in Australia and you aren't an Australian citizen, or if there's an AVO that's protecting either of you from each other, you'll need to gather those documents because the court will need them. In green, we kind of have the extras. So these are the things that you might want to include if you want to, but there's no obligation for you to. So parenting orders or care orders, these are good to satisfy the court if the proper arrangements have been made. Criteria, property orders or binding financial agreements. I mean, if you want to provide them to the court, you definitely can, but there's, as I said, there's no requirement to do that whatsoever at all if you don't want to. So ultimately, we want to make sure that we've got all these documents, but if we don't, step 2 speaks to the requirement to complete an affidavit. And an affidavit is ultimately, it's a legal document that you use to capture your written evidence or statements about your matter. Now, in the run-of-the-mill, not complex, very straightforward divorce, you won't have to complete an affidavit at all because you'll have all of the supporting documents that you need. So this is only, and I stress, only if you don't have the supporting documents that apply to you. And the common situations where we find these I've listed here. So this is where you don't have your marriage certificate. So this is you basically writing an affidavit in lieu of a marriage certificate to the court saying, I've tried to contact the country where I was married in and they don't have a record of it, but this is the date I was married, etc. If you do have a marriage certificate, but it's in a language other than English, you're going to need to file an affidavit to translate that marriage certificate into English. If you've been married less than 2 years and you don't have a counselling certificate, so this is where you'd want to tell the court the reasons why you haven't taken those steps to get that certificate. And usually the 2 best reasons or excuses for this is if you've been a victim of domestic or family violence and doing so would simply put you at risk. Or if you simply don't know where your ex-partner is and therefore you can't contact them to invite them to that counselling service. If you've been separated under the same roof, what we talked about previously, all those light green boxes, they're the types of evidence that you need to include in your affidavit about how you were living together separated, but under the same roof. And this is also a requirement for a third party as well. So that's where I was talking about a family member or a friend. They will also need to do an affidavit to say, yeah, I had a conversation with blah and they said they separated. I view them not in a relationship from X date, for example. Your surname is different to that switch on your marriage certificate or your maiden name, and you don't have that change of name certificate. So you'll just have to explain how that change of name came about and why that is. The court just needs to make sure that you ultimately are who you say you are. And if you're having any difficulties serving your spouse, you'll also have to write an affidavit. I won't give some examples about that now because I'll go into that in more detail in a little while. But that's just a bit of a snapshot as to the affidavits that you might need to complete. And you'll see at the bottom here, there's a step-by-step guide for preparing an affidavit. I'll just go into this quickly when it loads. So this is actually a really good resource. It's from Law Access, which is a part of Legal Aid, from the Representing Yourself section here. Ultimately, I'll just make sure, yes, you can see the screen. When we're sort of going through the divorce processes, we have step-by-step guides for every situation that you'll come across. So I really do encourage you to have a look at these. But if we just scroll down a little bit, so here's one just sample. So affidavit in lieu of a marriage certificate. So if you don't have your marriage certificate, you can have a look here at the instructions for completing it, and then also a sample affidavit as well. And that for every thing that I've listed here, we've got samples and instructions on that website. Once we've got all the supporting documents and we've completed any affidavits that we need, we now move on to step 3, which is the actual filing and submitting of your divorce application online. So again, if you remember what I said earlier about this being an online application, you will get a lot of pushback from the registry if you're attending in person. So I really encourage you to try to follow this, this guide and submit your application online. I won't go through each of the steps today. And again, you'll see in the bottom corner here, we do have our step-by-step guides for applying for the divorce order. That will take you literally walk you through everything that you need to do. But when we look here at the Commonwealth Courts portal, I want to speak to this very briefly. This is the portal or the online system where you submit all of your documents. So if we're looking here, this is kind of what it looks like. And then you've got the Register Now button here, and that's where you kind of start your process in registering and then following the prompts to apply. If you just type into Google Commonwealth Courts portal, that will be the first link that pops up. And then we're just following the prompts, as I said, to create the divorce application, enter all of the details that you need, download and sign a document called Affidavit of E-Filing. Again, you'll be prompted to do this throughout the process, and that Affidavit of E-Filing basically just says, you're signing your life away to say everything that I've told you is true and correct to the best of my knowledge. You'll pay the fee. So at the moment, the fee is $990. If you cannot afford that, for example, you might be eligible for a fee reduction. Again, down the bottom here, we've got applying for a fee reduction step-by-step guide. But the fee reduction, I think if you're eligible, it's about $330. It changes from time to time. So as at 10 May 2023, those are the fees. But you can just check the Family Courts website if you wanted an updated information about what it costs. Then you choose the court date and the hearing date, and then you can download any of your sealed court documents that you filed. If you have any troubles with that process, if you get stuck at all, the first kind of go-to, especially if it's just your administrative, technological kind of issues, would be to contact the court's call centre, and that's called the National Inquiry Line. I'll attach their contact details towards the bottom of my email towards the bottom of my PowerPoint, and you'll be able to give them a call if you need. If they're more substantive questions that you're like, oh, I don't know how to answer this question, then that's the point where you might need to give us a call and we can get some legal advice assistance for you to be able to help you through that process. If you filed a joint application, your to-do list stops here. Remember, I said you don't have to worry about, or you can ignore me when I talk about anything relating to service. So it's only if you've submitted a sole application that you have a few more things that you need to tick off. So the next step, step 4, this is about serving the court documents. Really important that today I'm only able to cover service in Australia. So if you're needing to serve a divorce application outside of Australia, so overseas, this won't necessarily apply to you, and that the process may be different. So I really encourage you to get some more targeted legal advice about that situation if that applies. So when lawyers say service or you need to serve those court documents, again, it basically means you're giving the court documents that you filed to your ex-partner, and doing this is actually really important. It ultimately notifies your ex-partner that you've started the court proceedings. It provides them with all the court documents that you filed, so they're aware, they're in the know, and they have the opportunity to respond if they want to. There are time limits, very important to follow if you're going to serve your documents. Within Australia, you've got 28 days before the date of your divorce hearing. Outside of Australia, that's extended even more to 42 days. Again, I've put a handy link to the bottom right that attaches the step-by-step guides for serving court documents. And again, really encourage you guys to have a look at those because they will go into way more detail than what I have the capacity to do today. When we're looking at documents to be served, it really depends ultimately on what documents you've needed to complete and have filed. The definite musts I have listed here. So we need our application of divorce that we've filed. We need to serve the affidavit of e-filing. We need to serve a document called an acknowledgement of service. And this is a blank document because the applicant doesn't fill this out. That's for the respondent to fill out. And then a marriage, families and separation brochure. And there's a link there for you to be able to access that brochure online. If you have completed or filed any affidavits, you will also need to include them in your documents to be served pile. The process as to how you serve can be a little bit complicated, but I've hopefully broken it down in a bit of a simple way to explain to you today. And again, I've done a bit of a traffic light approach. So in green, this is what I consider to be the very easiest option to serve a document, and that's if they have a lawyer and that lawyer has agreed to accept service, you can serve all the court documents on your lawyer. It's the easiest because it's literally, you don't have to fill out any other documents. You just serve it. The lawyer will fill out the document called an acknowledgement of service and give it back to you. And then all you have to do is upload that and your job is done. The orange is my next go-to if they don't have a lawyer or the lawyer doesn't agree to accept service, and that's serving documents by hand. Importantly, cannot be done by the applicant. So if you're applying for the divorce, you can't serve those documents yourself. You need to find somebody else who's over 18, or you need to hire a professional process server. And sometimes the professional process server can be a lot easier. They're very, very experienced. They know what forms to fill out and how to do so correctly. And if you just type into Google professional process server in your local area, one will pop up and you can start making inquiries to get them to do it. But if you don't want to pay a professional process server to do it, don't stress, and you can get somebody else to do it who's over 18. In red is my least favorite option because it really relies on your ex-partner completing and returning the acknowledgement of service document to you. If they don't complete it and return it to you, then you need to reserve it by hand. And in my experience, it's quite common that reservice needs to occur. So if we can just save the hassle and serve the documents to their lawyer by hand, serve the documents to the lawyer or by hand, it's going to be much easier, and we definitely should do that. If you don't know where your ex-partner is, you need to actively try and find them or find contact details for them. Some examples of what you might need to do I've listed here. So making inquiries with friends, family members or employers, calling any previous known numbers, writing to or attending their last known residential address, writing to their last known email address, searching them on social media or doing a telephone directory search. They're usually my go-tos. If you can't find their residential address, so therefore you can't serve them by hand or you can't serve them by post, then but you have, for example, found them on social media, or you have a telephone number for them, like a mobile telephone number for them, or you have an email address for them, you can seek an order for what we call substituted service. So this is basically asking the court to allow you to serve your ex-partner in ways other than by hand or by post, which is what the court primarily allows you to do through original service. If you can't locate them at all, you may be able to ask the court for an order for dispensation of service, which means we're not serving them at all and the court's waiving the requirement for you to have to do that. That's a bit more of a complex one and a tricky one. It's quite a lot when you think about it, asking the court to say, no, I don't want my ex-partner to know that this is happening. So in terms of getting the court to make that order, I'd really encourage you, before you're asking the court to do that, to reach out and get some legal advice so we can talk to you about your prospects of success and other things that you might want to try before asking for that type of an order. Again, very handy step-by-step guides. I promise I'll stop talking about them in a moment, but they are really, really good, and they walk you through this process of applying for the substituted and dispensation of service orders as well. The last step is uploading the documents online. And the purpose of this is really to prove to the court that you've done what's required of you. So giving your ex-partner copies of the court documents so they were aware of the proceedings. And what service documents you upload will really depend on the method of service you took. So I've listed it all here again. So if you've served their lawyer, you don't need to complete anything. Their lawyer needs to complete the affidavit of service. You just need to upload it. By hand, the person who has served it, so either the person over 18 that you know or the professional process server, they need to complete the affidavit of service by hand document. If your ex-partner returns the acknowledgement of service, you can upload that as well. And you'll also need to do an affidavit proving signature. And basically that affidavit proving signature basically says their signature that they've signed on the acknowledgement of service, you recognize that as theirs. That's all that means. By post, same thing as by hand, but you're just doing a different document called affidavit of service by post, but there is that requirement that your ex-partner has to return that acknowledgement of service, and you therefore have to also do that affidavit proving signature. There's a link here that I've attached. I'll go to quickly if it'll load for me. That has your do-it-yourself service kit. So this has all of the documents that I just spoke about to you previously. I'll just minimize these so I can show them to you. So the first it's really useful. They kind of just explain what the words are that's used throughout the court process in these documents. We're just going to go over this though. So here's a sample of what your affidavit of service by post divorce document looks like. So if you do it by post, this is what you'll need to complete. If you do an affidavit of service by hand, well, not you, remember, we're doing either the person over 18 or the process server. They are completing this document, and this is 2 pages. And then we've got the acknowledgement of service by divorce. We're not completing this, not the applicant. This is for the respondent to be able to complete. And then the affidavit proving signature. So they're really, they sound a little bit complex and complicated, and they've got weird names sometimes, but they're quite small, they're not onerous, and it's all together in this divorce service kit that you can just get online as well. So once service is complete, the applicant ultimately just needs to wait to see if the respondent files a response or not. So if you're the respondent, I'll talk to you about the 3 options that you have in responding to an application. You can either agree and just do nothing, or you can send back the completed acknowledgement of service. You can correct any errors in the application by filing a document called a response to a divorce. Errors, for example, might include incorrect name or spelling of name, incorrect date of separation. So if they say May 2025, we know that that's going to be an error. So we can just complete the response to a divorce and say the date of separation is actually May 2019, for example. If there's any if you don't agree with the arrangements that's listed about the care of your children under 18, you can correct those as well. The third option is that you can oppose the divorce order and ask that the court dismiss the application. But when we're talking about this, it's not just, I don't want a divorce, so I'm going to oppose it. The court will make a divorce order if they're satisfied of those things that we went through previously. So you're really only in a position to oppose the divorce order if you haven't been separated for 12 months and you can provide evidence to prove that, or the court doesn't have jurisdiction. So either you're not in a legal marriage, so the court can't make a divorce order, or one of you guys aren't an Australian citizen or regard Australia as home, for example. Going to the divorce hearing. So we'll quickly talk about this. Divorce hearings are all held online or via telephone. So you can't attend court in person unless you've given the tick of approval to be able to do that. And just prior to the hearing, you'll be given dial-in details for your court event with the link to be able to access or a telephone number to be able to call in on. I suppose the question then turns to go to the hearing or not to go to the hearing. If you filed a joint application, you don't have to go to the hearing, full stop. If you filed a sole application and these three things or one of these three things occur, you will have to attend the divorce hearing. If you're the respondent and you do file a response to an application in divorce and you're opposing the divorce order, then you will also have to attend the hearing. So it's not all circumstances that you have to, you always can if you want to, but it's only these circumstances where you filed the sole application that you will need to, or if you're the respondent and you're opposing it. Some practical things. You must be prepared for a number of different divorce applications to be in the list. So just because your matter's listed at 10:30 or 9:30 doesn't mean that it will be called or heard right away. So you have to definitely be dialed in by this time, but you need to wait until your matter's called. Once it is, take yourself off mute and respond to the registrar when prompted. So they might say, for example, the matter of Campbell and Campbell, and I will say, yes, I'm the applicant, Ms. Campbell, and then they'll move on to the respondent, making sure everybody's there. Court etiquette just in general is we're not eating, drinking or anything like that when we're in court, and that's whether we're there in person or on Microsoft Teams or over the telephone. We can't have any children under 18 attending with us. Yes, we can have a support person, but you're the only one who's going to be speaking when prompted to do so by the registrar. If you have something pressing that you want to tell the registrar or the court, you're more than welcome to, but wait for an appropriate time. You'll usually find that at the end, once they've asked their questions and got their things out of the way, they will then allow some time and say, does anybody have anything else to say before moving on to the next matter? If they don't, you can just politely interject and say something like, registrar, I had a quick question, or I wanted to raise some issues. Is now a good time to be able to do that? And they'll be able to assist you navigate that. The three most common things that occur during a divorce hearing would be either a divorce order is made, and usually they're quite straightforward, and the court will just make the divorce order on the first return date. If there's a little bit more to do, for example, you do need to get substituted service order and to be able to serve them by email, telephone, or through social media, for example, the court will adjourn it, allow for time for that to happen. If the court needs more evidence as to what your relationship was like or something like that, again, the court can adjourn it and give you sort of more firm directions and orders to be able to submit whatever it is that you're needing to submit. If the court's not satisfied that they have the jurisdiction, they can also just dismiss those proceedings right there and then. Preparing for the divorce hearing, confirm when your hearing is. That's really, really important. We've got to make sure that you actually attend so the court just doesn't dismiss it. I've put a link down here where it says the New South Wales Federal Circuit and Family Court of Australia. That will go through to the registry's contact information that you need if you need to send them an email address an email to be able to confirm when your divorce hearing is. You can also look at it and you'll find those details on the Commonwealth Courts portal too. Make sure you're reading over your court documents, reading over your ex-partner's court documents and planning what you need to tell the court. After court, you'll get the divorce order 1 month and 1 day from the date of your divorce hearing. So this is really important. Some people think, amazing, I'll have the divorce hearing and then I'll get it straight away so I can marry the next day. Not the case. Especially if you're planning a wedding, don't just assume that. Assume that the divorce order will be made 1 month and 1 day from the date of the divorce hearing. It's not automatic. This is a really important one. So there is a time limit that applies. So if you're thinking about dividing assets of your relationship, once you've got the divorce order, you've only got 12 months from the date of that divorce order to do so. Otherwise, the court closes their doors and it can be just a little bit more difficult to get through those doors. So my advice is always that if you're looking to do a property settlement, don't even think about doing a divorce. Sort those things out first and then look to do a divorce afterwards. The extra little bits, after a divorce order, you just might want to consider these things. They're not a requirement, but things for you to consider: changing your name, updating your beneficiaries, changing your will, and then what I talked about just before, dividing the assets and making sure we do that within 12 months. This part's all about how you can actually get some more practical help for your clients. So this is my favorite do-it-yourself step-by-step guides that you can find from our Law Access website. We also have Legal Aid New South Wales fact sheets, which are very, very helpful as well. And then the step-by-step as well from the Federal Circuit and Family Court of Australia is really good as well. So I'd encourage you to just check out those links if you're interested. If you or your clients need that extra bit of legal assistance, Legal Aid does offer a grant for divorce applications, but to be eligible, there is quite a strict policy that you have to meet. So first is our means test. There's a means test indicator link here, so you can you'll answer a bunch of questions and it'll shoot out a response to say either you're likely or unlikely to be eligible for legal aid based on your financial circumstances. You then need to meet our merit test. I won't go into that. It's all online and it's kind of briefly summarized here. But these bottom two, complexity of the matter and personal circumstances of the applicant, these are those extra sort of circumstances that we need to consider to look to approving a grant of legal aid. So for complexity, for example, there needs to be language barriers that might affect somebody's ability to navigate the court system. If there's some difficulties in proving the marriage, if you need substituted or dispensation of service, or if there's any sort of like forced marriage as well, that would satisfy our complexity criteria. For personal circumstances, ultimately we need to be satisfied that due to some form of a disadvantage, it's necessary for us to intervene. And that might be experiencing or at risk of domestic or family violence, if you've got an ongoing health condition or disability which significantly impacts your ability to navigate this system yourself, or if you're experiencing quite significant financial hardship. If they are likely to be eligible for legal aid, get them to call us. Even if they're not, get them to call us and we'll be able to answer any quick questions that they have or determine their eligibility as well. You can contact us on the legal aid numbers here through Law Access, through any sort of local offices, or if there is domestic or family violence, I'd really encourage you to contact our domestic violence unit. We've got the National Inquiry Centre here, the number that I promised you before. So if you're having any difficulties navigating the Commonwealth Courts portal, this is going to be your go-to. If you're not eligible for legal aid, there are some community legal centres out there who might be able to assist. This is their policies dependent, so there's no guarantee there, but there's a link there that kind of helps you navigate which is your closest community legal centre where you might be able to make some inquiries. And then you've got a private lawyer. So if not eligible for legal aid, you don't want to do it yourself and you want to pay someone, go for it, and you can choose a private solicitor to represent you. That is me done and dusted. If you guys have any questions, please pop them in the box and we'll go through them, but I'll pass it back over to you, Bridget.
Thanks. Thanks so much, Cailey. That was a great presentation. We don't have any open questions at the moment, but there was something I wanted to ask. When you were talking about having to complete an affidavit because you need to translate a certificate. In terms of the translation, do you have to use an officially certified translator when you're having any documents translated from another language?
Yes, absolutely. So the affidavit of translation will be completed not by you, but by the person who is authorized, the authorized translator, and they will complete that and change it from whatever language it is into English. So it can't just be you doing it or a friend or a family doing it. It needs to be somebody that's qualified.
Thank you. And something else that occurred to me when somebody is having difficulty locating their ex-partner and they take those search steps that you suggested,
Yep.
It would be really useful for them to keep file notes of all the attempts that they've made, because they'll have to complete an affidavit after that. Is that
Correct.
right?
Yes. So usually I say duck down to Big W, get yourself a little bit of a notepad and a pen. And when you're making those inquiries, put the date. So 10 May, 12 May, whatever it is, called X person who is in, X relationship to my ex partner, they said, and then even as verbatim as possible, put the conversation. If you're doing your searches online through social media, again, putting the date that you've done those searches, what sort of information you've typed in and what sort of responses you got. So all of those things are good. Even if you have a copy of like an email address or a text message that you tried to send, getting a screenshot of that and annexing it, which basically means attaching it to your affidavit to prove to the court that you've definitely sent that. That's the more evidence that you have, the better your case is going to be to either get that substituted service order or order to dispensation, dispense with service. Yeah.
And I suppose similarly, if you're separated under the one roof,
Yes.
Noting the things that you're no longer doing together, that all helps with evidence of that separation.
Absolutely. And even things like, again, those, while there's not a requirement for you to get it in writing, it's really only if the court's pushing back on it or the other party is pushing back on the date of separation. Even if you have those messages that say, hey, your laundry is here, I'm not doing it, or something like that. That is just those little bit more of evidence to be able to help you satisfy the court that you weren't doing their laundry and that you were separated under that one roof. So all of those types of things are really, really handy too. So even if you're not breaking up with them over text message, even if it's you messaging your family or friends saying, hey, Rob and I or Sally and I just separated, then you've got the timestamp of that text message as well. And then you've got a third party also saying, I received this text message from this date. I viewed their relationship to be over. So all of that, noting it down, really important, because yes, thanks for acknowledging that, Bridget. All of that stuff is going to be needed to put in your affidavit.
Fantastic. We've had a couple of questions now. Regarding the eligibility to apply for divorce, either being a citizen having lived in Australia for 12 months or intending on residing here, does this also mean the person can't have left Australia to go on an overseas holiday during that initial 12-month period?
No, go on many holidays as you want to. It's about your really viewing Australia as home. So if you've got an Australian citizenship, you don't need to worry about this at all. But if you don't, it's just you predominantly residing in Australia and considering Australia your home. So even if you go on an extended holiday, that won't be a problem in the eyes of the court. It might be that you need evidence to speak to that though. So it's just a tick box that you'll find on the application for divorce. You'll just tick one of these things that apply to you. And if the court wants more information about it, they can ask you, for example, to complete an affidavit. And that's where you'll speak to, I've lived in Australia from X date. I went on a holiday on X date to X date. It wasn't me, changing residence or anything like that. I came back to Australia on X date, all of those sorts of things.
Thanks, Cailey. And Ricky's asked a question. Ricky's helping a client apply for a divorce. It's a joint application. Both parties are on Centrelink benefits, and it keeps wanting to charge $330. Is there any way to further reduce the cost that you're aware of?
Well, potentially. So there's two ways that you can reduce the fee. One is the way that you guys must have done it, which is saying that you have like the pensioner card or a healthcare card, or you're on Centrelink, and so that reduces it from the $9.90 to the $3.30. The only way to kind of reduce it even further is there's another document, and I'm happy. Was it Ricky? We can get your email address, for example, and we can send this link through to you. But that speaks about financial hardship, and then it's really at the discretion of the registry manager as to whether they want to reduce that even further, depending on what both parties' financial circumstances are. So potentially, but there's just no guarantee. It's completely at the discretion. But if you want to try, we can send you the form that you guys will need to fill out, and you can submit that to the registry manager to see what they come back with and say.
Thanks, Cailey. Another question we've had is, if you're doing asset distribution, I imagine they mean property settlement. Is that the term that you would use? Wouldn't that be evidence enough of the divorce date?
No.
Or perhaps separation date? I'm not sure.
So short answer to that is no. Oh, sorry, I interrupted. Does that question
there's
go
just
on?
a little bit more. Also, wouldn't the private lawyer be enough to confirm the date of the actual divorce, seeing how there would be negotiations with the lawyer?
So you can get, when we're talking about property settlement, as I said, remember property, parenting, divorce, 3 very different things. So property settlement you can do the day after you separate. So just because you enter into a binding financial agreement or you've got consent orders or court orders, that still doesn't mean that you've been separated for 12 months. So the court in a divorce, they won't consider the date that you've divided your assets or anything like that. The only thing that they will consider is the date that you have separated. So if, for example, in those negotiations through those private lawyers, you've agreed on a date of separation, then yes, that can definitely help. But just the fact alone that you've entered into that agreement isn't going to satisfy the court that you've been separated for that 12 months, because you can do that the day after you separate. I hope that answers that question.
Michael's asking, in what circumstances would legal aid be available for divorce? He's thinking specifically of having the filing fee covered.
Yeah, so when I spoke about, I'll go back to here where we looked at eligibility. So again, these things need to all be satisfied. So and yes, if you're eligible for legal aid will cover all of the filing fees and things like that, so you won't have to pay. But when we're looking at your eligibility, we look at the means test, so their financial circumstances and whether they meet that for legal aid or not. Merit test, so to making sure ultimately that there's prospects of success in the application, and then they have to complete, or they have to satisfy rather, the complexity and the personal circumstances. So if they satisfy all of those things, and I've linked here the complexity and the personal circumstances as well. So if we just open this up quickly, these are, I'll make sure that you can see it. I don't know whether that's zoomed in enough or not for you guys, but they're the examples that I spoke about earlier, that one of those definitely has to apply. And then if we go to the personal circumstances, one of these have to apply as well. So if you tick all of those boxes, or your client ticks all of those boxes, please give us a call, or you think they will, give us a call. We can book an appointment in to chat to a lawyer, and then that lawyer can determine your eligibility for legal aid in that appointment. But you have to satisfy these criteria to be eligible.
Thanks, Cailey, for clarifying that. I also wanted to let people know before we finish the webinar that I did upload into the chat a copy of Cailey's presentation. There's a PDF handout there that you can download from the chat while the webinar is running, but I will also provide a link in the email that you receive after the webinar so that you can download the PDF if you're not able to do it during the webinar today. And I don't know if I mentioned at the start, but this webinar is being recorded and will be uploaded onto the Legal Aid YouTube channel in a day or so after the webinar finishes today. So if there's anything that you want to clarify by listening again, you can access the recording easily on our YouTube channel, and you can also refer other people to it if they haven't been able to attend the webinar today. Just check if there's been any further. No, it doesn't look like we've had any further questions. So some people have had to leave and some people are saying, oh, sorry, there is one more now. Would divorce laws apply to a de facto relationship the same way?
No, so I mean, divorce is only to end a marriage. So if you're in a de facto relationship, there's no, not only is there no requirement, you physically can't get a divorce even if you wanted to. If you've registered your de facto relationship through like Service New South Wales, for example, you can deregister it, and there's steps that you can take to be able to do that. You can call us up to get legal advice about your targeted situation if you want. But no, for a de facto relationship, if you're not married, you can't get a divorce.
Thank you, Cailey. And yeah, we've got some contact details for Ricky to send the extra paperwork through. Thanks, Ricky, for sharing that. And we've got a little bit of time left, but if there aren't any further questions from people, then I'd like to thank Cailey very much for the clear presentation and the step-by-step information. If for some reason people can't access the chat, don't worry, because you'll receive an email after the webinar, and I will include a link to the PDF document in that email, so you'll be able to access it that way. And yes, as I said, the recording will be available on our YouTube channel. So thank you, Cailey, and thanks everybody for attending and listening to the presentation. And I'll finish the webinar now. Bye, everybody.